services. That relates to group 2. Yes. When the complaint was, the notification dated 7/12/2023 was against the judgments of the Honorable Supreme Court in Daria case in respect of horizontal reservations. Though they are not supposed to merit fixed roster points, they have fixed roster points, and the notification themselves mirrored show that roster points are fixed. Now, they have come up with this counter affidavit. Kindly see the counter affidavit mirrored of APPSC.
Today we filed 3 counters with the USR number. Four 633. For arguing 4633.
9373 counter is handled over.
Analysis counter now we are playing because in the recent cases we added something in the. So which one do you want to refer? 9373 maybe. 9373. This is a now common counter. In all counters we are adopting. That's listen.
Yes. More or less, all the contents of all the counters are one and the same. However, since my learned friend says that counter in 9373 is updated, I will rely on this. But the counter basically 3 points. They say they have strictly followed GOMS number 77. That is what they say. Secondly, they reiterate the fact, according to them, they have not indicated any roster points. They have not given any roster points for horizontal reservation. That is what they say. 3, which is more important, third point, they say they have indicated the reservations to be followed for horizontal reservations, but they have not given roster points. But incidentally, what they say is the indents sent by the departments. I have pointed out one or two cases to your lordships. The indents sent themselves point out 2 roster points. So APPSC, though evasively saying that they have not given any roster points, what they mean to say in effect is we have indicated the points as given in the indents, which means roster points. Secondly, but most importantly, what they fail to understand the concept, the difference between vertical reservations and horizontal reservations. Here, they justify the posts being reserved for horizontal categories on the ground that the departments have sent indents showing the inadequacy. What is inadequacy? They don't explain. Probably, from reading the counter, what I understand is, suppose if one department says, we do not have enough women, 33 point women, we don't have. So, that is the reason why they have indicated certain points for women. That is what the counter says. But this flies in the face of GO 77, as well as, my lord, judgments of the Honorable Supreme Court. I was trying to explain to your lordships, my lord, in respect of vertical reservations, the question of adequacy arises. In the total number of posts in a particular cadre, at any point of time, if the government feels that there are, my lord, enough SCs are not there in the department, they can always, my lord, reserve the posts, or if they are not filled up, they can be sent as backlog posts. Suppose in this 2023 recruitment, they don't find, my lord, enough SC candidates to fill up SC reserved posts. Those posts will be carried forward to the next recruitment. That is the concept of vertical reservations. Insofar as horizontal reservations are concerned, they should only ensure that there are 33.5 women. They cannot reserve. And that is the reason why, even suppose in 2023, suppose miraculously 33.5% women are not there. Those posts will not be carried forward. They will be occupied by other categories. That is the concept of horizontal reservation, which they have not understood. Basically, there is nothing in this counter except these three. Now, straight court, which clearly delineates the difference between the vertical and horizontal reservation. This is a very short paragraph. I just read it so that the emptiness of the counter will come out. Internal page 598. The other portions are also relevant, but I am straight away taking my lead to the most relevant portion. Paragraph 59. Yes. The features of vertical reservations are they cannot be filled by the open category or categories of candidates other than those specified and have to be filled by candidates of the social category concerned. Only SC, ST, OBC. Mobility. Migration from reserved specified category to unreserved open category slot is possible based on meritorious performance. Which means, suppose a candidate is selected under the SC category in an SC post, but according to merit, he also comes within the open category. He will migrate from SC to open category. That is the meaning. 3. In case of migration from reserved to open category, the vacancy in the reserved category should be filled by another person from the same specified category lower in rank. If the vacancies cannot, this is important. If the vacancies cannot be filled by the specified categories due to shortfall of candidates, the vacancies are to be carried forward or dealt with appropriately by the rules. They cannot be filled up with other candidates. That is what they say. Next, horizontal reservations, on the other hand, by their nature, are not inviolate pools or carved in stone. They are premised on their overlaps and are interlocking reservations. As a sequel, they are to be calculated concurrently and along with the inviolate vertical or social reservation quotas by application of the various steps laid down with clarity in paragraph 21.3 of Lalit J's judgment. They cannot be carried forward. This sentence is very important. They cannot be carried forward. The first rule that applies to filling horizontal reservation quotas is one of adjustment. That is, examining whether on merit any of the horizontal categories are adjusted in the merit list in the open category and then in the quota for such horizontal category within that particular specified social reservation. So, the notification is anyway wrong. Now the counter affidavit of APPSC supporting the notification that because certain departments have expressed that there are inadequate horizontal reserved categories, so they have indicated the reservations is wrong. Because the Supreme Court judgment clearly, we have understood the concept. Supreme Court also said in horizontal reservations there cannot be any carried forward. If the candidates are there, well and good. If candidates are not there, they will be filled up with candidates from the other categories. They cannot be very backlog. So this justification of the notification is wrong. This is very illegal. That is my humble submission. Coming to the counter affidavit of the government has filed its counter melody in WP 4633 of 2024. Surprisingly, the government admits paragraph 11. This counter affidavit is signed by
Assistant Secretary, AP Public Service Commission.
but it is as vague as it can be. None of the allegations of the various petitions are addressed. They simply give their own narration without meeting any of the points. Probably what I understand is, according to GO 77, they say earlier roster points were fixed for horizontal reservations also. Now we have done away with that. That is what they, even that is not clear. Because everything, kindly see page 35, paragraph 43.
Of your repetition,
Is counter affidavit.
counter of 4633.
4633.
That's only 18 paras.
Point counter.
State counter.
State counter.
Respondent counter. Respondent.
Secretary to the government. Aid.
Para?
And paragraph 11, they explain the initial situation where roster points were fixed for women also. That is not in dispute. And later they say finally at paragraph 43, in principle, they accept that according to this judgment, roster points should not be assigned. Kindly see paragraph 43, Mother. Further, in terms of judgment of Honorable Supreme Court of India in Anil Kumar Gupta, etc. versus State of Uttar Pradesh, dated 28/7/1995, and Rajesh Kumar Daria versus Rajasthan Public Service Commission, the government has deleted the roster allotted to women category, persons with disability, ex-servicemen, meritorious sports persons, duly increasing the reservation from 3 to 4% for persons with benchmark disability in terms of Rights of Persons with Disability Act 2016. The roster points should not be assigned to the categories come under the horizontal reservation, that is women category, persons with disability, ex-servicemen, meritorious sports person, as per the judgment of the apex court in Anil Kumar Gupta, etc. versus State of Uttar Pradesh, dated so and so, and Rajesh Kumar Daria versus Rajasthan Public Service Commission, so and so. This is all. So in principle, they say earlier we had reservations, roster points. Now we don't have roster points. That is what they say in the counter affidavit.
Paragraph 44, they say vacancies were notified by earmarking to women as per recruitment, as per requirement of unit officer to meet women representation horizontally.
Which is contrary to the above paragraphs. They cannot do that.
What does this signify?
The contention of the petitioner, the government have fixed wrongly the roster for other categories. OCs, scheduled caste, scheduled tribes, backward classes in DIPA is not tenable. With regard to assertions in para so and so, it is submitted that vacancies were notified by earmarking to women as per the requirement of unit officer to meet women representation horizontally, which means in effect roster points are fixed. This is exactly what APPSC is also saying. No, they want to wriggle out of the situation. We have pointed out that in the notification, you have very specifically delineated that so and so posts are reserved for women. Number of posts are reserved for women. That is what they say in the notification. I have pointed out. Now they want to take advantage of the fact that the notification does not specify roster points. Notification says so many posts are reserved for women, PBD, etc. They want to wriggle out of the situation and say that adequacy of women are underrepresented, so we are filling up these vacancies with women. That is what they say, which is not permissible.
They can't even indicate how many women are.
Cannot indicate. They have, see, in the notification, my lord, they have said 33 1/3% ensured that is there. Once that is there, number of posts does not arise because there are no posts reserved for women. Except for vertical reservations, there are no reserved posts. So you could not have identified any posts for women. That is entire.
And they say that, see, out of 100, if you apply 33.5, so maybe 33 or 34 posts can be accommodated for women. Can't say that.
They cannot say because I have pointed out your lordship.
Not saying specifically that these posts will be filled up at so and so roster.
That
33.5% generally presupposes that.
I understand. That argument, my lord, will not fit into these facts because in respect of certain posts, I have pointed out to your lordships, 44% of the posts are reserved for women. In respect of certain posts, 50% were reserved. So this argument will not fit into the facts. This is a very general counter, except one or two sentences here and there. Particularly, as your lordships have pointed out, 44, they admit that they have indicated certain posts for women. We have done that because the department said women are underrepresented, so we have indicated. That is what they say. That is also impermissible. This is what my submission. They cannot do that. I will once again, for not wasting your lordship's time, I will point out to their
Page 112 you referred to last.
112 I already Malad, I have 125 Malad. One two five.
Yes.
In the top reservations, women.
Yes.
Zonal cadre, the third post, zonal cadre, zone 2. One post in OC and one post in BCD is reserved for women. Next page it continues. In SC, one post is reserved. Next page also, my lord. In each of the zones, they can again for PBD, persons with benchmark disabilities, 126 my lord.
Requisition form.
Yes. This is the form that is sent by the department to the APPSC, basing on which this notification is issued. Kindly see PBD, reservation 4. There cannot be any reservation. You said 4% posts will be reserved for PBD, which means after recruitment, after you prepare the merit list, you will have to ensure that 4% of the candidates belong to persons with benchmark disabilities. There cannot be roster point fixed. Here they fix the roster point. Kindly see.
Who prepared this requisition
These are the in the departments.
format? Because this format seems to be uniform to all.
Yes, it is uniform. Andhra Pradesh Public Service Commission Vijayawada. So it is APPSC which has given this format. Kindly see page 120. Andhra Pradesh Public Service Commission Vijayawada requisition form for direct recruitment. So in this form, the departments have filled up Malad according to their knowledge and wisdom. They have filled up. Kindly see page 145, Malad. This is a more glaring example.
Come to page 128
128.
plus Roman 5. All A. What does this mean?
Where 128 is meritorious sports person.
Yes, we need that. We need that. Other details.
Other detail. Whether the exercise of adequacy of women PBD MSP ex-servicemen vacancies is made in terms of GOMS number 77, yes. Number of vacancies lapsed during the previous recruitment, nil.
What does this GO say? Does this GO says to
Yes, yes.
take
At one place it says you should find out the adequacy and send the, that is in general guideline, not to fix roster points. When the GO very specifically approves judgments of the Honorable Supreme Court, extracts the portions and says there are no roster points fixed, the department cannot go against it. My humble submission is they have gone against it not intentionally. According to earlier practices, they have done this. But the APPSC will have to be found fault with. Mechanically, the department, certain secretary, under-secretary level people send these. They may not be aware of the legal position. It is for the APPSC that its certification is in accordance with the rules and the Supreme Court judgments. They should have immediately sent back these requisitions. Kindly see 145, my lord.
Yes.
This is actually 144. It starts. It is about what the column is about vertical reservations.
Then horizontal.
Horizontal 145. But they are so obsessed with this horizontal reservations, even in vertical reservations, kindly see zonal cadre, zone 1. They specify women categories on the top, women slots on the top. Kindly see. Which is all not required. In several places, you will logically find women. So obsessed with women, I don't know why. Zonal cadre 3 also. Next page, it is very evident. And finally, horizontal reservations, women reservation, quota to be filled. OC 5, BCD 1, BCE 1, SC 1, EWS 1. Similarly is the case with all other posts also.
Maybe quota we are referring to is 33.5%. Don't have any quarrel if they just mention 33.5% and leave it
They
there.
have already mentioned. Just 1 minute notification launch on kindly.
There are 4 more minutes.
Kindly see notification alert page 236. Two 230 minute in repetition 3306.
331.
My repetition 3306.
They are following
Only refer to 3306. Even earlier also I referred to 3306. Internal page.
in this.
3306.
Refer to some page 236.
Yes. That is what he is saying. 3306.
The counter page 26 minute, 24.
Yes, that will do.
24. Easy to refer one paper book. Because again,
Earlier also I have referred to the same paper.
yes. Page
236, the notification starts. Reservations. Very clear, my lord. Para 4.1 refers to vertical reservations. Percentages are given in Rule 22. Next, see 4.2 women reservations 33 1 by 3 in terms of Rule 22. It is also mentioned. Next, persons with benchmark disabilities. Para 4.3.
yes.
So everything is there. Further, they need not go and say anything about merit posts, which they have done. That is at page 269. Against each post, starting from municipal commissioner, they have indicated the number of posts reserved for women among the vertical reservations. For every post, till 288. From 269 to 288, for every post, they refer to the exact number of posts reserved for women, which cannot be done because you do not know. Well, Lordships have understood the concept from the judgments of the Honorable Supreme Court. Now, as of now, we do not know where the women will fit in. So the question of reservation does not arise. Only after there are no 100 posts. 50 posts are open category. 50 posts are for SC, ST, BC. Only after you prepare the select list of 100, you will come to know whether there are enough women or not. If there are enough women or not there, then you will have to delete the last meritorious candidate from the open category, from the SC category, ST category, BC, EBC category, and fill up with women. Then you will come to know where women will be placed. Now you do not know. So without knowing it, if you are indicating, which means you have equated these reservations with vertical reservations. It's so simple, my lord. They give you evasive reply in the counter rather than fairly admitting to your lordships. But this is the truth. So what happens? Article 14 is affected now. You have reduced the number of posts which are open for candidates to compete by saying that so-and-so posts are reserved for women, PBD and ex-servicemen. You have reduced the chances of the open categories and SC, ST, EBC candidates also, because they are also eligible to compete for all the 100 posts. Thereby Article 14 is offended. Tomorrow, now this gives rise to legitimate expectation.
Now, how are you prejudiced because of mentioning this here?
Because, see, but this...
As you are meritorious, you will not get...
Even if I am not meritorious or meritorious, what happens is, municipal commissioner post. Municipal commissioner post can either be reserved for SC, BC, OC or left open. It cannot be reserved to anybody. Now it is reserved, so I cannot compete. When I cannot compete, without any reasonable restriction under the Constitution,
Suppose if there is only one vacancy.
one vacancy cannot be reserved.
There is only one vacancy just to test extreme proposition. There is one vacancy, now they are notifying. So, in that vacancy, as per that requisition made by them, if at all if it's being shown as women, then completely no other candidate other than women what has been notified there. Qualifiedly they take it that they are not...
I'll explain that. Well, what happens is, as I have explained earlier, in respect of SC, ST, BC reservations, suppose if they are not filled up because candidates are not available, the post will be carried forward and next recruitment they will fill up. The other posts, there cannot be any backlog vacancies. If they are filled up, well and good. If they are not filled up, they should
No candidate, then they will go with whoever are there as per
that
merit.
is the situation.
Okay.
Now, suppose in this recruitment there are about 500 posts, say. 500 posts, as per the constitutional mandate, they can be reserved for SC, ST and EBC. I have no complaint. I cannot have complaint, though my milord, I have a grouse against it. But constitutionally they are accepted. I cannot say my choices are curtailed. I cannot say that because that is constitutionally mandated. More than that, if the government does anything, that affects Article 14. So now here,
Now if they are saying we are not following any roster and all, it is only an indicative thing. We have
if you are indicating,
we just indicated and leave it. It's as if as looking from the point of 33.5% reservation.
that cannot be said because this is a affair of the government, administration of the government. Now the 100 posts they say 50 are reserved for women. In effect they have said that 50% women reservation is not provided in the constitution. Obviously you are cutting out all the other candidates from competing. That is the reason why it offends Article 14. There is no question of indicating. That is what I have read out to your lordships. You cannot indicate. You cannot reserve. Only vertical reservations you can do. Horizontal you cannot. Once you reserve means you are offending Article 14. You are sending me away from the zone of consideration. My learned friend wants to answer that.
See, maybe you can do it once you let him come. After that,
No, the specific query, Lordship permits EO 77, Your Lordship may kindly say, Lord, for a moment, any paper book Your Lordship may take, Your Lordship may kindly see internal page 24. Per page. But the foundation for the argument on behalf of the petitioner is based on GO 7. So this GO runs about 30 pages. 11 pages are allocated for background. What all that background had been stated, reiterated in the counter. They did not meet the points raised in the repeat. Now, answer your Lordship's question. Internal page 24. And you see, general guidelines for all administrative departments. Because it is very, the line to be drawn is very thin. Because Your Lordship's question was very pertinent and the entire gambit rests upon the question put by Your Lordship. Kindly see the guideline. The administrative department and the competent authorities shall take up the exercise of adequacy of representative for women. We are now concerned with women only, persons with benchmark disability, and ex-service and meritorious sports persons in every cycle of 100 points as per the respective percentage provided to the category.
what does this mean?
Percentages that's already there given in the
Not percent.
22.
What kind of exercise they are supposed to undertake now as per this?
That will be my answer for Your Lordship's query. I am coming to that point. So, Your Lordship may see this GO 77, when it was introduced, it comes into effect from the date it was issued. There is no dispute with regard to that. With regard to its applicability or prospectivity or retrospectivity. By that time, given in a cadre of some group to post of ACTU, let us say earlier 46 posts per trainer in a cycle. Because so many cycles are there, the latest cycle may not stop at 46. Then 47th point is to be commenced. If 47th point is to be commenced, already, and at this point, I am filling up only 10 posts. That means commission notifies only 10 posts. In those 10 posts, normally 3 posts will be reserved, have to be reserved for women. Not reserved, horizontally to be filled by women. That's what Your Lordships are thinking. That 3 posts are to be filled by women. What is wrong if number 3 is mentioned? Am I right?
No, I didn't say number 3.
No,
I only said.
Your Lordship said 10 posts are to be filled up, 3 posts to women. What is wrong if that 3 posts meant for women is
Those 3 will be placed at what roster point? I am not on that. I was only just trying to say 3.5% has to be met as per this particular table. So what is wrong in just indicating that 33.5 will be there,
Yes.
and out of say 10, suppose in a given case there are 10 vacancies are to be notified. So 10 of 33 corresponding to 3 posts. Women 3, that's what they seem to have done. I'm just putting a question.
It appears like that only. Now what happens, in 46 vacancies already filled up. If there are more than 4 women, if there are 15 women, there need not be any specific reservation.
That is the purpose of doing this adequacy exercise. See, what they seem to have done, tabular form and all, what maybe something to what they are going to argue. How many women candidates are already there within the vacant, the posts already working there?
Yes.
And then out of the vacancies, whether totally put together they will meet 33.5%.
And that shortfall to be looked into, and that shortfall to be looked into is also not, they are not aware of it. But actually, your lordship have seen page 24 now. Kindly see page 35. Item 2.
Yes.
If the quota is already filled up with the earlier recruitment, then the equal number of vacancies reserved for the shall be deleted. Then item 3. After clearance from Government and Finance Department for filling up vacancies in direct recruitment, or any other recruiting agency should be clearly mention quota-wise roster points where the last recruitment was stopped and roster points for the new recruitment is to be commenced. And the adequacy shall be clearly specified. Now, your lordship will see this with reference to physically handicapped. Coming back to below page 21.
Yes.
In Roman 5 on the top, there is a possibility that none of the vacancies, they said 1 to 25. There is a slab they fixed. There is a possibility that none of the vacancies from 1 to 25 is suitable for any category of the person with benchmark disability. In that case, 2 vacancies from 26 to 50 shall be filled as reserved for persons with benchmark disability.
So how do these people get to know whether how many vacancies are there?
They should not know. They should not know. Women need to know that of the entire number of posts being filled up, 33.5 representation will be ensured. More than that, they should not know anything.
Only at the end.
This adequacy exercise, unless they undertake it, suppose if there are no vacancies at all falling into that particular category, then what is the point in just mentioning 33.5%, 3%, 5%,
That is the
8%?
reason why I want to submit this is an incongruous exercise. They should not have done that. That is not necessary at all. In fact, according to R.K. Sabarwal's case, adequacy should be found out at the end of each recruitment, which they are not doing anyway. We can't insist at this point of time. Unnecessarily for horizontal reservations, they have done that, which is not required. As I have pointed out to your lordships, Supreme Court said there cannot be any backlogs for horizontal. When there are no backlogs, each recruitment is a fresh recruitment. All that you can do is to ensure that so and so percentage of people, women are there, PVDs are there, ex-servicemen are there. For that, the way that is to be done is explained in Daria's case. Lordships have read it. Once again, I'll read it very short. It says, simply says, you suppose SC merit, SC reservation falls for consideration for the APPSC.
These general guidelines then probably would not apply to horizontal at all.
No,
They will apply
it
to
can
vertical.
Vertical it may apply, because vertical they can do it. That is what Supreme Court said also.
They're not concerned with what happened in previous exercise.
They should not be concerned.
33.5%, they are gone.
Gone.
You can't ask to again refurbish those.
It is not possible, Merit. Kindly see Daria's judgment, paragraph 9, Merit, for a minute. Page 363.
Rajesh Kumar Daria.
Yes.
358.
Yes. Paragraph 9, Lordship. Subparagraph I'll read. Save time. paragraph 9, there is a subpara.
Yes, para 9.
Yes, subpara is there. Let us illustrate by example. They give an example in the subparagraph. It begins with if 19 posts.
Thousand 780 cc, 785. Is it changes?
2007 8 SCC.
Means the second related
Exactly.
to. Yes.
Subpara is there giving an illustration. Let us illustrate by an example. It begins with if 19 posts are reserved.
And 91.
But the book only, I'm just referring to page 363. 363.
Paragraph 9, there is a subpara in the bottom, above 10.
If 19 posts.
Exactly.
Yes.
That is what I mean. If 19 posts are reserved for SCs, of which the quota for women is 4, 19 SC candidates shall have to be first listed in accordance with merit from out of the successful eligible candidates. If such list of 19 candidates contains 4 SC women candidates, then there is no need to disturb the list by including any further SC woman candidate. On the other hand, if the list of 19 SC candidates contains only 2 women candidates, then the next 2 SC women candidates in accordance with merit will have to be included in the list, and corresponding number of candidates from the bottom of the such list shall have to be deleted so as to ensure that the final 19 selected SC candidates contain 4 women SC candidates. But if the list of 19 SC candidates contains more than 4 women candidates selected on own merit, all of them will continue in the list, and there is no question of deleting the excess women candidates on the ground that SC women have been selected in excess of the prescribed. This is how horizontal reservation method is actually administered. So, which means, as of now, at the time of issuing notification, accept the intention that 33.5% of the post will have to be reserved for women. I do not know anything more. There is no possibility, if you follow the law, you have absolutely no possibility of knowing how many posts will go to women. So the question of indicating that in the notification falls foul of this judgment.
Yes.
So the way they have indicated in the notification, which your lordships have already seen, kindly come to page 269 once again, just a minute.
Yes.
269. Postcode 2, sub-registrar. Sub-registrar, there are total 16 posts.
Yes.
OC 7, BCA 1, BCB 1, BCD 2, SC 3, ST 1, EWS 1.
They are all vertical.
Vertical. Only this you can know at the time of notification.
Vote should not have been there.
They cannot. Now coming bottom, among the 2 vacancies, the following are reserved horizontally. How do you know? This person with benchmark disability may be selected to some other post. We don't know. Once the merit list is ready, my lord, Suppose a person PBH is there,
Already there is a PBH, then there will
there is no
be
need. So how do you know this post goes to PBH? Which means this is arbitrary. You are following vertical mode of reservation for horizontal reservations also.
There
In
can be
essence,
more than one PBH also.
Yes.
that is exactly our point.
Yes.
Now, there is another complication. In certain posts which I have pointed out to your lordships, more than 50% have been reserved for women. Tomorrow, if this, whether there is a chance for the APPSA to correct itself or not, that is what I am saying. It cannot correct itself. This notification will have to go in toto. If they correct itself, what will these women say? Don't they have a legitimate expectation that all these posts are reserved for us? Midway can they now say, no, we will follow the Daria case, we'll only after the entire merit list is prepared, we'll give you reservations. Can they say that?
Let us see what they are going to say.
They cannot. No.
What they are going to say.
Before that, I will have to address that point also. They cannot say, they cannot be allowed to say that we will correct ourselves in the process. They cannot correct themselves because they have these poor candidates, they have given them the scope of aspiration.
Legitimate expectation.
Expectation will be there. They will definitely say, so and so post is reserved for us. Now you are saying because of some Daria judgment you are not going to give. So there will be a lot of complications, legal complications if this notification is allowed to go. That is my humble submission. Right, anything is there, I will reply in that time. Right.
Yes.
I don't take the lordships to all that factual aspect. Only the lordship would kindly see the notification at internal page 12, whichever is the paper book.
Yes.
Luckily there is an internal page 12, the lordship may kindly see. Para 4.1 is reservation, 4.2. There shall be reservation to women horizontally to an extent of 33 1/3%. Then my lord comes to benchmark disabilities. That was all described in para 4.6 and 7. Now kindly see my lord 4.9. The reservation to meritorious sports person will apply as per GO 13. That is all preferences, my lord, etc.
Where are we reading? Page?
Page, internal page 12, bottom, 4.9.
It starts with the
Notification.
Notification, yes.
Yes. It starts with para 4 reservations.
Page 195. Amendments. Starts with amendments at the bottom. Sub Rule 2 of Clause 22 following shall be substituted. This is internal para 12 of the notification.
Para 4 of the notification. Para 4 reservations. Just now my friend read out. Internal page there on the top right side.
I have at bottom in this book. There is a roster table is there. 100 roster table is there before that page.
258.
258.
Page 258 in there.
195. Long way to go. 250. Notification.
Yes.
Yes.
Yes. The talking about it is para 4 reservations.
Yes.
4.9. Your Lordship may kindly see.
4.9.
4.9. The reservation to meritorious sports person will apply as per GO so and so. My lord, so many GOs are mentioned. And in the bold, they have stated, in the event of non-availability of eligible meritorious sports persons, 2% reservation of post for them stand lapse. And as per GOMS number 77, dated 2/8/23. My lord, this GO also spoke about GO 77, which is an amendment to the rules. This is, my lord, amendment to Rule 22 by way of, my lord, under the powers vested under 309 of the Constitution. So that's what they have to follow. Any notification, my lord, it is a fundamental principle of law that it should be in consonance with the statutory rules. If no rules are there, my lord, then the Commission has all the power to frame their own guidelines. So they are supposed to proceed in accordance with the rules. My lord, your lordships were pleased to see all through that, my lord, when my friend was arguing, that, my lord, GO 77 clearly speaks about deletion of the words women. Women were, and the consequential GO 3 was specifically issued because they missed, by issuing GO 77, they omitted certain, my lord, they have not taken care of certain aspects of that amendment, which was again redressed by themselves by issuing GOMS number 3, that was in January 24. In that GO, all the words wherever the woman was used, that was deleted. So 77 had categorically stated, my lord, in the notification which was issued, to omit or delete the word woman. They have specifically stated. Kindly see, my lord, the GO internal page, your lordship may.
277.
Yes. They have given 3 steps, my lord. Kindly see, my lord, internal page 17. That is the bottom of the GO.
Special reservation. 22B.
22B, capital B, special reservation,
Yes.
horizontal reservation. Kindly turn to the next page, my lord. Illustration. After that, my lord, para 2. Sequence to be followed while filling up the post. First step, open competition quota on merit basis. Second step, vertical reservations quota, which include SC, ST, BC and EWS. Third step, find out horizontal reservations quota position, which includes women, persons with benchmark disability, ex-servicemen, and meritorious sports persons. Out of the quota to be filled in, out of the filled in quota, as first and second step. So this